procedure than we usually use. But by the time we get the recommendations to the committee, they're very heavily staff drafted and our best shot at it. But because of the nature of this subject and these recommendations, Kaja and Jeremy Grayboys, who I should have thanked as well, our research director, and I thought it would be best to kind of get you all involved in the draft recommendations earlier than usual. And of course, timing is everything. We saw action by the Judicial Conference recently, a week or so ago on this subject. So I look forward to any comments on that. Thanks very much. Let's get to work, and back to you, Kaja.
Thanks. I'm just going to turn it right back over to Kirti. Thank you.
All right, thanks. So just some housekeeping opening remarks. So first, please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the Judicial Review Committee and their alternates, can have full speaking privileges. To avoid background noise, please keep yourself on mute and then either use the hand raise function in Zoom or add a comment in the chat feature if you'd like to speak. And I will then call on you and you can unmute yourself at that point. And once you're done speaking, please remute yourself. I'd also ask that ACUS members and alternates use the webcam during today's meeting to facilitate conversation. And I'll also just ask if your name on Zoom doesn't clearly indicate who you are, it might be helpful to rename yourself, which will make calling on you easier. With respect to any attendees other than ACUS members or alternates, although I don't think we have any, but in case anybody just joined, participation requires the unanimous consent of committee members, and I will consider on calling on such attendees at appropriate points. If any such participant would like to speak, please indicate so in the chat or again by using Zoom's hand raise feature and wait until I call on you. For all participants, please only use the chat feature to indicate that you'd like to speak, or I don't think we'll be voting today, but to the extent we are, to vote when asked. Please don't put any sidebar discussions or substantive comments into the chat box. If we do end up voting on anything today, only members of the Judicial Review Committee will be able to have a vote. Please do not vote unless you're a member of the Judicial Review Committee. And if you're unsure at all, you can always ask Kasia, who has a list. And with that, I'll turn it over to Joe to present his work.
Thank you, Kirti. Thank you all for letting me be part of this project. Just to briefly level set, Congress has made agency rules presumptively reviewable in court, but it hasn't always specified where that review takes place, which is the reason for this project. The default rule is that agency rules or challenges to agency rules are brought in federal district court under default federal question jurisdiction with default rules of venue and so forth. But, as illustrated by the incredibly helpful source book, there are hundreds of times where Congress creates a direct review provision that either allows or requires challenges to rules be brought directly in the circuit court. Sometimes these direct review provisions say the challenge can be brought in whatever circuit the challenger happens to reside in. Other times they have to be brought in the DC circuit. So as I understood the assignment, there are basically three buckets of questions. The first is drafting ambiguities in these direct review statutory provisions. The second is questions about the vertical allocation of judicial review. And by that, I primarily mean, should challenges to agency rules be vested directly in the circuit court, bypassing the district court, or should the normal process of federal litigation, where cases start in the district court and then appeal, apply? And then the final bucket is horizontal review choices. So assuming a level of court, should there be restrictions on basically venue, where those challenges can be brought? So to answer these questions, I undertook a literature review and a survey of Supreme Court and circuit case law. And turning to each bucket, for the first bucket on drafting, I identify several recurring issues of drafting across these direct review provisions. The three that I want to highlight, the first is that in the 1980s, the Supreme Court adopted a presumption in favor of direct circuit review. And I think that presumption has less weight these days as textualism becomes a more dominant mode of interpretation. And so going forward, Congress should be mindful that the presumption may no longer hold as much sway as it once did, and draft statutory direct review provisions with precision. The second is there's a lot of circuit precedent interpreting statutes that provide for judicial review of orders to also include judicial review of rules, notwithstanding the APA's default language that defines order to include everything other than a rule. And that has led to some ambiguity. Courts have come out different ways, primarily in the DC Circuit. The word order includes the agency action that constitutes rules. But going forward, if Congress intends to provide a direct review provision to include challenges to rules, it should say so explicitly and not rely on the word order to accomplish that. The third drafting ambiguity that comes up regularly, many direct review provisions are triggered only if the agency acts under like a particular statutory provision, under 87GA or something like that. Oftentimes it's unclear which statutory provision the agency is acting under, as when the agency might, cite a variety of statutes that justify its action. Or the plaintiff might argue that, in fact, the rule is issued under one substantive provision and the agency argues it's under another. So drafting direct review provisions mindful of that possibility is something that can avoid jurisdictional ambiguity going forward. The second bucket of questions that I address are about vertical allocation of power. And so that, I discussed, there have been a variety of proposals that people have made over the last, 50 years. But primarily, this is a question of whether challenges to rules should be vested directly in the circuit court, bypassing the district court, or whether the usual rules should apply. Generally, I've written on this in the past. I think arguments in favor of direct circuit court review of agency action are overstated. But given ACUS's longtime recommendation favoring direct circuit review and the unique features of challenges to regulations, which benefit from expeditious resolution by the judiciary, I do think that direct review in the circuit court should be the dominant mode of reviewing agency regulations. The third bucket has to do with venue. In the report, I discussed pros and cons of requiring challengers to agency rules to bring their challenges in a specific court. Say everything has to be brought in the DC Circuit. I ultimately decide that the case has not been made for that type of process. But instead, I come up with two other recommendations. And these assume that the challenges to rules will not be vested directly in the circuit court. So if challenges to rules can continue to be brought in district court, then I think two things should happen. The first is, there's been a lot of chatter on this recently. I agree with the Judicial Conference, the American Bar Association, and pretty much everyone else, that we should eliminate division shopping by providing for random assignment of judges to challenges to federal regulations, and that random assignment be based across an entire federal district and not based on particular divisions. And the second is, I think there should be a process for consolidating cases brought challenging the same regulation in different districts. The MDL process is rarely used, and I don't think it's as effective as the process for consolidation that exists at the circuit court level. So that's just a brief summary, and I look forward to this conversation.
Okay, great. Thanks, Joe. So I think the way we're going to structure this, as already indicated, this is a bit of an unusual process. So I think first we're going to open it to if people have general reactions to Joe's report and want to discuss or offer views on that. And then later we're going to put the recommendations that Joe just summarized up on the screen, and we'll go one by one to talk at a pretty high level of generality about whether those are worth pushing forward with to draft the kind of highly reticulated language that ACUS recommendations usually come in. So first, the general comments portion of today's meeting. If you'd like to offer comments, please either raise your hand or let me know in the chat and I will recognize you. Okay, great. Ron?
I just wanted to say, I think it's an outstanding report. It's very thorough. It brought out a lot of dimensions that I was not aware of, even though I've done some scholarship in this area. It comes across very even-handed. And so I look forward to our discussion of the particulars. I don't have other general messages to make, but I just want to say, I thought he did a really good job and will be very helpful to us.
Thanks for that. Does anyone else have general comments? Okay. Hasia, do we want to put up the recommendations now then?
Yep, I will pull that up. All right, so everybody should be able to see this.
Do you think we could maybe zoom in on,
Yes.
that'd be great. Thanks. Okay, great. So maybe we can start, we'll just start at the top with the first potential recommendation about what Congress should take from the modern trend towards protectionism. Joe, is there anything else you want to say about this one, or should we just turn it right over to, okay, great. So for this, we're just looking for if anybody has strong feelings one way or the other about whether this recommendation should be included or shouldn't be included, and then any comments on the details of any such recommendation. And obviously this wording is just to pose the idea and not, it's not going to be reflected in any final recommendation. So less about the wording and more about the topics. If anybody would like to speak, just raise your hand or let me know in the chat. Great, Professor Morrison.
So I don't think that this first recommendation is going to have any impact. Telling Congress how to draft statutes is, just spitting into the wind or something else similar. It just won't do it. Let me ask Joe, maybe you considered the possibility of taking this presumption instead of having it a judicial presumption, but have Congress enact it as a presumption into the law so that the textualists would have to follow that. I mean, I could hardly oppose the drafting because I agree with the sentiment that they should be clearer, but that's sort of a not a very good, especially as an opening recommendation for ACUS. That doesn't show much creativity and thought of the body as a whole. If that's what we can do. So what about a put it in the statute? When in doubt, we mean to go to the Court of Appeals. I have a bunch of other questions about agency rules on that score, but I just want to raise that one first.
Ron, did you want to say something on the same point? If not, I'll turn it to Joe and then go back to you.
He can respond. It's related, but if you want to get him to react to that first, or
Yeah, okay.
Take on
Let's give Joe a chance on that, and then I'll come to you next.
Yeah, no, thanks. I actually have, as I've written elsewhere, been very critical of the presumption. I don't think that it is helpful, and indeed, I think it introduces a layer of additional ambiguity because in addition to trying to let me say two things on this. The first is when Congress vests jurisdiction over a particular provision in the Court of Appeals, it doesn't necessarily want everything, that the agency does in the Court of Appeals. It should be thought of as trying to say, no, this part should go to the Court of Appeals and other parts should go wherever else they belong. I don't know that I think the presumption is, I guess, unwarranted in terms of as a empirical matter of understanding how Congress acts. And I think it's confusing because it forces courts to kind of interpret the language, but then, say well, there's this presumption, but how strong is the presumption? Is it overcome here? And I I actually think the textual approach is better. So I personally would not favor enacting the presumption in statute.
Okay.
And sorry, Joe, did you have any response on the value of providing drafting guidance other than?
Sorry, Curdy, I didn't mean to cut you off. Yeah, I agree that, this is kind of a vague command, like just remember the basic rules of statutory construction when you're drafting statutes. I do think the longstanding nature of this particular presumption, dating back to the 1980s, I guess I don't have enough familiarity with ACUS's process and specific recommendation approaches, but making drafting decisions that are not based on a presumption of direct circuit review, but knowing that these provisions will be interpreted according to whatever textualist approaches, might encourage Congress in some ideal world to draft with more precision than they often do with these direct review provisions.
Okay, thanks, Joe. Professor Levin?
Okay. Notwithstanding what I said a couple of minutes ago, I'm somewhat critical of this recommendation. First of all, I think telling Congress to be precise is pretty much of a parenthood sentiment, previously known as a motherhood sentiment. Of course, they should be precise insofar as they have something to say. Purposeful ambiguity is not something we would recommend. If they agree on something, they should say it. And if they haven't said something clear, it's because they haven't reached agreement. And I agree with Alan, we're not going to influence that. They have so many reasons to be specific about something and not about others. They're not paying attention to an administrative conference recommendation that says, tell us what you mean, because it is just, it's vacuous. And I also would not adopt a statutory presumption. I think that will just cause even more interpretive difficulties deciding to what extent the presumption applies in a given situation and in what way it doesn't. What I think there really is no tension between textualism and a presumption. The textualists will tell you that they're receptive to presumptions. They don't try to say everything should turn on exact language. I think most, at least, of the theorists in that area will say, yeah, well, sure, there's a role for judicial presumptions or clear statement rules or the like. Maybe weak, maybe strong. Justice Barrett recently wrote on this subject and made clear that she doesn't particularly like substantive presumptions, but then goes on and in effect endorses the major questions doctrine on what analytically is the same basis. She acknowledges that they exist. So even a so-called textualist doesn't really reject it. I think to respond to the spirit of Joe's comment, rather than get into the jurisprudence of textualism versus something else, I think what we should do is act in AGUS's area of strength, which is speaking as clear as best we can to circumstances in which the presumption is a good idea and which is not a good idea. And if it's vacuous now, then we should say, okay, under certain circumstances, the presumption should be maintained, and in some circumstances, it's inappropriate. And then we're giving the world the benefit of what we do have, which is some expertise in this subject area. And I would not get into the issue of textualism versus anything else. I would just try to the extent we can to advise Congress and judges about how we think ambiguity should be resolved, recognizing that if Congress does specify something, obviously that will be the law.
Okay, thank you for that. Are there others that wanted to offer views on this first potential recommendation? Okay,
If there's any
um,
ambiguity, I support Ron. I agree with Ron. And I withdraw my suggestion that including a rule of construction. I agree that it's not useful.
okay, thanks, Professor Morrison. Okay, then hearing or seeing no other folks who want to chime in on this one. I think among, taking in all this feedback, we can also look at prior ACUS recommendations to see the extent to which they've offered similar drafting guidance, and then we can glean any best principles from that. So we'll move on to the next potential recommendation, though I think it'll raise some of the same comments. But let's go to that one next. And again, if you'd like to say anything in response to this potential recommendation, just raise your hand or put a note in the chat. Thomas?
I hope you can hear me okay. My question is actually about both this and the previous recommendation. Is there any concern that they may be construed, let's assume Congress actually does what we're recommending, an unlikely event to be sure, as Alan pointed out, but still, if we're including this, I think we have to contemplate the possibility Congress acts on these recommendations. If it does so prospectively, does that call into doubt court decisions interpreting previous statutes that did not follow these recommendations? Is there any concern about retroactive effect, in other words, of these kinds of recommendations? And if so, should that be addressed in the language of the recommendation?
Joe, did you have any immediate responses to that?
I think that is a concern. I think one possibility would be to recommend that Congress, if Congress does intend to have order include rule for purposes of direct review statutes, then it could adopt a statute that kind of adopts the current judicial interpretation that includes rules in orders. But I don't have a further thought beyond that.
Thanks, Joe. Matt?
Just one comment. I'm agnostic on the number one, though I'm generally agree with what Ron and Alan said and so forth. One point I would like to make with respect to tactical drafting matters of the sort that's reflected in the second recommendation, specifying order versus rule or both of them and so forth and so on. I wouldn't entirely underestimate the impact of a specific ACUS recommendation on a technical drafting point, its impact on the offices of legislative counsel. I do think that is a consumer of ACUS's work. And if a recommendation on a point like this is sufficiently specific, I think there may be some value in communicating that through a recommendation or maybe through other means to the offices of legislative counsel. Because most of the committee drafters and the staff drafters are very inattentive to issues of the sort that are reflected in the second recommendation. That's all I have to say.
Thanks, Matt. Professor Morrison?
How about calling me Alan, okay? My mother didn't call me professor, so there's no reason for you to call me. two things. One, I agree with Matt, and some of the things that we're talking about here could be put in the preamble, and I think Ledge Council probably will read preambles that even if we don't put them in the recommendation. And this may not be the right place to talk about it, but in various places in the report, and I have some additional questions about what we mean, what is encompassed when we say rules? That is to say, does the failure to issue a rule, does the unreasonable delay constitute a rule? And then you have things like the DACA and DAPA, which were not formally called rules, or the Trump Muslim ban orders, which were not called rules, but which most of us thought should have been labeled rules. What do we do about challenges to those? So maybe we could have if the chair wants to do it here or someplace else, try to have a discussion about what we mean by rules of the kind of things that belong in the Court of Appeals, leaving aside the other questions for just a second. I see Joe is nodding his head, and so maybe he agrees with me that we ought to talk about it at some point and try to figure out what we mean by, obviously, when it says this is a rule and under a specific statute, that's easy. But the question is, what else constitutes a rule? And I had not realized that the deny until I saw Joe's paper that the denial of a petition to have issue rulemaking was in some places not considered a rule for purposes of the rule, but unreasonable delay was, and so who knows.
Thanks. Joe, did you want to respond and have anything to say about whether you were relying on any particular definition of rule and order in this?
I was not. I recognize that ambiguity. The scope of the project, I defer to you all to decide what that should look like.
Okay, thanks, Joe. Matt, was your hand still up or up again? Okay. Then Professor Simoni?
My hand is not up. I'm sorry. I will lower it. I apologize.
No problem.
Okay. Well, first, I just wanted to say that I thought that the report was just remarkably well written and clear, and I learned a lot from it. And so I don't know if this is a possible thing that ACUS does, but it seems to me that both this recommendation and the preceding one might really be thought of not so much as recommendations, but more like just FYI, like be aware that this is a thing that is looming out there. As I read the report, I didn't get the impression that that courts were actually taking this different interpretation of, that they were actually reversing the presumption or refusing to read, orders as including rules. That it was more like it was a looming potential pitfall out there. And what the report is doing could maybe advising Congress of this risk rather than necessarily having an instruction or a direction or even a softer recommendation to Congress on what it should do. So if it's possible for ACUS, or if in earlier ACUS reports there is a precedent for the kind of FYI from ACUS to Congress, then maybe that's something that could be considered here. On the second recommendation as to the direct review provisions and referring to orders, rules explicitly, I just wanted to say that around page 65, text accompanying notes 65 through 68 in the report on page 10, I was a little surprised to see that the description that it was only in 1956 that the statute was interpreted to provide to read orders to encompass rules. My understanding of the case law is that in cases from well before then, orders that have been used to promulgate rules or of broad applicability were treated as reviewable, even though the statutes only spoke to orders. And in some of my research, I've talked about some of these cases, but it's like the assigned car case in Baltimore and Ohio, and the CBS and NBC, and there's a variety of other cases as well. Sometimes coming up under the Food, Drug, and Cosmetics Act, in which orders are really talking about kind of broad gauged regulatory action. So I don't think that this is something that came up in the 1950s, and I'm happy to send you those sites if those would be useful. But thank you again for writing this wonderful report. And I also wanted to say that I enjoyed your post yesterday on notice and comment, and thought that was very well done too.
Thanks, Joe. Did you have any response to that?
I will take a closer look at that, and I appreciate any additional material you can send me. It's certainly possible that there's a line of cases from history that I missed.
Okay, great, thanks. Are there any other folks who wanted to chime in on this second potential recommendation? If not, we will move along to the third. Albert?
Hi, I just wanted to echo what somebody said before, Thomas, I think. And so, I mean, I like the idea of whether it's an FYI or if it's something in the preamble, but I do have some real concerns about what Congress doing these kinds of things would mean for statutes that previously existed.
Okay, thank you, Albert. All right, last call for others to chime in on the second recommendation. Okay, then let's go to the third recommendation on drafting strategies to avoid potential manipulations. We'll open it up. If folks want to speak, again, raise your hand or let me know in the chat. Hazia, are you able to move the screen down to the fourth recommendation? Thanks. Okay, so we're open for comments on this recommendation about preferencing challenges to rulemakings in the circuit courts. Again, either raise your hand or note in the chat that you'd like to speak. Thomas, I saw your hand first.
I guess my question is about the scope of this potential recommendation. And again, considering sort of retrospectivity questions, would this subsume all prior statutes and sort of eliminate the questions in those statutes? And would it also then subsume the disputes that arose under those statutes about whether district court or direct appellate court review was appropriate under certain statutory provisions, or would it be prospective only? I guess that's a question mostly for Joe.
Joe, did you have a vision? It might just be me, but I couldn't hear you, Joe.
Sorry, can you hear me now? My microphone got bumped, I guess. I think that it makes sense to have it apply not just prospectively, but just in general, which would moot the interpretive difficulties of the past. It wouldn't like retroactively deprive a court of jurisdiction over a case that's been issued, but it would kind of moot the interpretive difficulties going forward, would be my response.
Okay, Alan?
So, all the questions I raised before about the scope of rules, we need to be, we need to confront them here. We either say yes, no, or whatever it is, but I don't think we can avoid it in this. Second, I guess one of the questions we raised here is, would this be a general statute? Applies across general jurisdictional statute like the opposite of 1331? Or would it be a agency by agency statute, subject matter by subject matter provision? And because if it's the former, that's a pretty radical change. And you know, I think it in many respects it's a good idea for reasons that we talked about before, as well as other reasons that we'll probably come to later on. But I guess that's question number one, and we certainly ought to be clear about what ACUS thinks about whether it should be a single statute or a subject by subject, agency by agency approach. And if it's a single statute, then presumably we deal with the retroactivity by saying it applies only to cases filed after such and such and applies to all cases. So we deal with that. It's more of a problem with retroactivity if we are doing on a lesser basis. But we still have to deal with these other I'll call them related rule questions at some point. And I guess we probably ought to have a discussion about what people think about these what I'll call related rulemaking questions.
Thanks, Alan. Joe, I want to give you a chance, otherwise we'll.
Just real quickly, 2 points. Both of these are driven by my concern about jurisdictional ambiguity. I would suggest a universal, like not agency by agency, but just a flat kind of rule that says, statute that says rules adopted under whatever set of circumstances should be brought directly in the Court of Appeals. I suggest having notice and comment rulemaking or formal rulemaking. Either of those processes as the hook by which a rule would be vested in the Court of Appeals, because they are relatively clear cut. You don't have the ambiguities of like the DACA-DAPA problem, and it allows rules that follow these processes will have the administrative record that is most conducive to direct circuit review, which is why I recommend that it be just rules that are the product of notice and comment rulemaking or formal rulemaking.
Thanks, Jared. Alan, did you have any follow-up based on that response?
I think we ought to have a discussion about that because, I mean, what do you do when somebody claims an exemption from notice and comment rulemaking? Or as in the DACA case, say it's not a rule. I mean, we have the record. The record is what the record is. It may not be very plentiful, but it is the record, and the agency has to defend it on that grounds. And the same is true for unreasonable delay or failure to rejecting a petition. The record is all there. And why should it have to go through a district court and go to a court of appeals? It imposes a lot of delay and costs on top of what's already taken place. So, and the same with DAPA. I mean, it was a legal question as to whether that was a rule or not, and whether any exceptions applied. So I guess if we're going to do this, I would in the spirit of trying to eliminate ambiguity and say and make it clear as we could that we intend for everything that if it were a final rule, it would go to the Court of Appeals. It should go to the Court of Appeals. but I'm open to debate on that. But that I think I agree with Joe that a universal rule would be advisable, because it would be simpler and first place possible to enact. I mean, we could never enact a rule for each one of the agencies or each one of the Congress could never do that. Each agency, let alone each specific statute.
Okay, thanks. Professor Levin, did you want to chime in on this point, or did you have another comment? I think you might still be on mute.
I wasn't trying to get into that discussion directly. I still wanted to speak to this recommendation, but
Okay, let me just.
it's an outgrowth of what Ellen has been talking about.
Okay, let me just check then with Matt if you had a comment on this specific point. If not, we'll.
I do. It's just a question, and I think Joe kind of got at it. What's the reason for this? When I originally read this recommendation, I had assumed that notice and comment was somehow sort of a marker or a proxy for something else, like the importance of a recommendation, the importance of a rule, or so forth and so on. But I think, as Alan pointed out, you do have to account for invocations of the good cause exemption, which are at least according to CRS, are very common. The exemption is the good cause exemption is invoked with some frequency with respect to rules that are very significant and are of real consequence. So that was my sort of question comment.
Yeah, I can pick up from there because it's just another.
Well, I just wanted to, Joe, just in case. Okay, great. Okay, then Professor Levin, go ahead.
So it's another formulation of the same set of issues. First of all, you could have a new statute, and there's actually a logical place for it to be incorporated or at least be referenced in the APA itself. Section 703 says the proper forum for judicial review is blah, blah, blah. You could add something to it that either puts a rule decision, or you can have a cross-reference to another statute that is more detailed and the like, if you thought that putting it in the APA itself was too cumbersome or too sacrilegious to a venerated object or something of that type. But what should it say? Well, so I think the most obvious possible modification you might make would be to make this apply to all rules with the force of law. And then rules that are exempt from notice and comment, but otherwise are legislative rules, like those relating to foreign relations or benefits, grants, and so forth. Those are legislative rules of similar significance. It's true that you may not have as full a record with regard to those because the agency doesn't have to conduct notice and comment. But if, as Alan says, you're stuck with the record you've got, you still have the same functional reason for going directly to the Court of Appeals. Now, guidance, I think, is a different category, really different category. And I would have much more hesitation about expanding beyond rules with the force of law that obviously have the force of law or intended to have the force of law. Because in the first place, guidance can be a huge category. And you've got a continuum between those that are perceived as having coercive effect and those that are argued to be such and those that aren't really. But, I think you'd have a lot of trouble drawing that line. And I don't think I'd want to make that a jurisdictional line. So you'd fight it out on the question of whether you're in the wrong forum in order to decide this really elusive question of whether the agency expressed itself in such coercive language or definitive language or, pardon the expression, binding language. I think this committee is familiar with the difficulties of that term, or how the agency implements it in practice. That really, I think, is going to be unworkable. So I think probably if we follow something in this vein, it would be rules that are, you'd have to figure out some way to say rules that are intended to have the force of law, but not to include those that have been artificially characterized as such, even though they're really interpretive rules or policy statements because of a desire to make them judicially reviewable somewhere. So that's probably where that might be a line to draw. And the last thing I would say is ACUS does have a similar recommendation on this in which they shied away from the flat rule that Joe is hinting at by saying, oh, there are a number of qualifiers and the like. He mentioned in his report, one of them was where the rule is thought to be too trivial, and he cast some doubt on that. I don't have a strong view there, but I think probably the conference should look at those exceptions that the earlier recommendation drew and think about whether we want to adhere to them or abandon them.
Thanks. Alan, I couldn't tell if your hand was up again or still up from before. Okay, great. Go ahead.
No, I think Ron has clarified part of it. He would put interpretive rules with guidance in the non-direct review category. I think that's what he said, and I agree with that. Second is, there are some agencies, the IRS in particular, goes through notice and comment on some occasions when it's issuing what it chooses to label as an interpretive rule. Seems to me if the agency labels something as an interpretive rule, it's not seeking to make it binding on others, and the jurisdiction should reflect that. So the fact that it went through notice and comment rulemaking would not be enough if it doesn't have the force and effect of law. But at least we ought to be, if I could be wrong, we could go the other way on that, but at least we ought to be clear that, that whether the fact of going through notice and comment rulemaking is in itself sufficient to trigger it, or whether it's just indicative of what normally happens under 553.
Okay, thanks. Joe, I'm going to give you a chance to respond if you have anything to say.
I mean, these are really good points. I think where we draw the line is tough. I would just, again, going back to jurisdictional ambiguity, making sure that, you know, a lot of these cases end up being litigated for years in the wrong court, or because there's a collapse of the merits with the jurisdictional question. So making sure that whatever line is drawn is least susceptible to that problem would be my recommendation. And this was the way that I thought the line was clearest, but I could just not be clever enough to think of a better way to do it.
Professor Levin?
And just to complicate it a little further, the Administrative Conference has long recommended that agencies should voluntarily use notice and comment rulemaking for interpretive rules and policy statements, that they intend to remain as such, but they just think it's a good idea to get people's comments and the like. And so the question would be, would they be included if the agency wasn't required by law to provide notice and comment rulemaking, but did anyway? And of course, if you do that, then you're creating incentive effects as to whether the agency is going to voluntarily do it. I'm not sure in which direction, but that may not be effects you want to create.
Okay, thank you. Are there any other members that wanted to speak on this potential recommendation? Alan? I think you're muted, Alan.
I think I have another reason why this recommendation makes sense, putting these in the courts of appeal. And that is for many years, the courts of appeals have not had the problem of worrying about national injunctions. When a rule is challenged, 3 judges decide whether it's going to go into effect. I had a number of cases earlier on involving OSHA rules, and the rule either went into effect, and the same is true with EPA rules. Either they went into effect or not, and we don't have any judge shopping in this case. We may have some court shopping, but we don't have the single judge shopping. And if an injunction is entered, it will be by a panel of 3 judges. And so to the extent that these cases go to the courts of appeal, you will lessen the possibility of single judge shopping, or even district judge, single district shopping. And that seems to me to be a good reason, probably not sufficient on its own, but certainly a reason why this will work. And to the extent that there are multiple courts in which these are brought, as they were with environmental rules and occupational safety rules, then we get the lottery system kicking in, so that further limits the ability of people to manipulate the courts. which I think is a positive outcome.
Thanks. Albert, I see your hands up.
Yeah, thanks. I may have missed this in the report, but does this contemplate that there a single circuit or regional circuits? And if regional circuits, is the lottery necessarily in effect for all of them?
Sorry, can I respond, Kirti?
Yeah, sorry.
Yes, this does not contemplate that they would be brought in a particular circuit. It would be the current rules of, whatever circuit the challenger is in, or the DC circuit with the lottery system kicked in if there are multiple challenges.
Okay. I'm gonna do a last call for comments on this potential recommendation. Okay, then let's move to the next potential recommendation on limitations on venue. Just want to start, I saw Judge Braden that you had made a comment in the chat, but I wanted to see if you'd be willing to explain that.
Only if you're looking to enlarge the number of people that may get an assignment, limiting it to just active judges is kind of contrary to that. I mean, don't you want to have as many potential judges available to take a lawsuit as possible? Same thing would be in the circuit court. I mean, you're not limited to just active judges in the circuit to look at the cases. I don't understand why the active judges was in the second recommendation. The other thing is, I'm not sure, I haven't had a chance to, frankly, to read whatever the judicial conference came out with in the last couple of days on this topic, but whoever the people are proposing this should just take a look at it. And apparently there's been a big, backlash in Congress on that, whatever the proposal was. So just a heads up to the person who is the staff people that are working on this data. Double check what the conference has done and then see what the response has been in Congress. It's probably primarily by the Republicans, as I understand it, but you have to take a look at it. Thank you.
Thanks. Joe, did you have a response?
Yeah, just two responses. The first is I'm not wedded to active judges. The reason why that's in there is because senior judges, as cases are assigned, they're often given a reduced workload. So they're not assigned, an equal share, I guess, of the district's workload in many circumstances. And so a random assignment rule would need to take into account that differentiation. And then when you start adding departures from a pure random assignment, every judge is given a 100 or an equal chance of receiving a case assignment. Then you start to get at well, why not, allow other departures? And I think it can create some difficulties, but there are ways around that, and that could just be a drafting issue. In terms of the backlash, I am aware of the backlash. I stand by this recommendation. I think that it is a sound principle of judicial administration that should apply. And welcome further thoughts on that.
Thanks, Joe. Are there others with comments on this particular recommendation? Alan?
No, we're only limited in this recommendation. We're limited only in the recommendation to rules. Is that right? So we should make it clear if that's all we can talk about, that it shouldn't be that ACUS is not taking a position on anything else beyond rules, because some of the same mischief occurs when things are not rules or when things are outside the scope of even the administrative state. So that was one. Okay, all right. Yeah, I think that's yes. That's all. That's the only thing I had on that.
Thanks, Alan. Professor Sahoni, I saw your hand up next.
Yeah, I just had a question, a clarification question. Like, it seems to me that D and F are sort of cutting in different directions, and I wondered if you, in which order you're supposed to apply those. Like, if all of the rules are going to be in circuit court, then what's the consolidation lottery of 2012? 2112 going to apply to in the district court? Is it like either or back, is F a backstop to D or what?
Yeah, Joe, did you want to go ahead and respond to that one?
Yeah, I was envisioning that D, putting them all in circuit courts, was the frontline answer, but assuming that is not accomplished, E and F are kind of what can be done in the absence of D.
Okay, I think that it would be helpful to say that in the thing.
Thanks for that. Professor Levin? I think need to unmute your mic there.
Right. So obviously I'm in favor of the judicial conference proposal or something like it. You'll find buried in Joe's footnotes quote from me saying I can't conceive of any public purpose that judge shopping serves. I compared it in my article to saying you'd be able to pick which 3 members of the Court of Appeals would hear your appeal. You know, it just seems completely unacceptable. Now, as far as the backlash is concerned, some of it is coming from, I would say, people with strong ideological associations, which I think of as being basically partisan, and saying the judge shopping is being used well by people who are on our side, so why would you shut it down? I mean, I'm not saying that, but I think I interpret that motive. But in addition to that, you have chief judges of some of the districts in Texas saying, oh man, do you realize how big Texas is? You have huge distances involved in these cases, and you're going to make it random. That's going to be a big imposition on a lot of people in a lot of cases. And I don't think that's necessarily driven by ideology, although it may be to some extent. You can't really tell. I think that is at least something to keep in mind in terms of defining the scope of whatever rule should obtain. But another thing it brings to mind is that these are the judges who are being addressed by the Judicial Conference, and they are not apparently disposed to go along with it. So if you've been thinking, oh, the Judicial Conference has solved all this, I would not take that for granted. I think it may require something, may require legislation.
Thanks for that. Alan?
So with respect to the last recommendation on the lottery, I was one of the early supporters when ACUS was getting started on the 2112 lottery. My recollection is that the lottery was keyed largely because of the fact that in many of these situations there were time limits for filing the appeal and whether petition for review, whatever it's called. And second is there were conflicts on both sides. That is, the environmentalists said that the EPA was not going fast enough, far enough, and the industry was saying they're too far. The same is true in the labor situation, in the OSHA situation, and undoubtedly true in others as well. My experience is that the cases that are the district court rules, especially the judge shopping rules, there aren't a lot of these cases going around. They're all filed in one direction. I mean, the time that this would have kicked in was when there were multiple challenges to the Trump so-called Muslim ban rule. But other than that, I don't remember a large number of the census. There were maybe 2 or 3 cases, but not and not necessarily. They were shopping around because they had different plaintiffs and who had different venues. But there were not a lot of them. And as far as the MDL is concerned, the MDL, as Joe points out, is many more cases than this. And second, it's only for pretrial purposes, so that doesn't do you any good at all in these circumstances. So I'm not sure that we really need this lottery recommendation, and particularly where we'd have to set up a time frame for within it should have to be brought, and that would raise some complexities. There's also an issue about, there's a case in the Supreme Court now about statutes of limitations on challenging rules that went into effect a long time ago. And I wonder how something like a consolidated lottery procedure would fall when we're talking about 6-year statute of limitations. Now, I guess I'm not sure that we need this recommendation, but I may be wrong about that.
Thanks, Alan. I think just want to make sure there aren't any other additional comments on the second recommendation on the screen before we get to the consolidation lottery recommendation. So just want to give folks a chance on that. And if not, then we can move on. So now we'll open up the discussion to views on the consolidation lottery recommendation. Alan's already gotten us started. Are there others who want to be heard on this issue? Professor Levin, I saw you just came off mute.
I'm thinking about it a little bit here. Give me a few moments to collect my thoughts. So I guess one thing I was thinking about, and I haven't fully formed a position on this, is that consolidation works only in a limited number of situations. It's going to work. It would work in situations like the race to the courthouse problem that Akis faced earlier, where you have two different opponents of the regulation filing in different districts, and you have to choose between them. And the race to the courthouse provision was driven by races to the courthouse. That is where people were under a statute where the first to file would automatically get the case. And so the remedial legislation, which Akis pioneered and has taken credit for since, deservedly, is to say as long as you file within a certain window, you don't get a time priority. But I think one of the reasons why this doesn't exactly fit the template of the recent controversies is that the objections to judge shopping have been from people who are opposed to the rule. They're not worried about different people filing in opposition who favor the rule. They're not worried about different people who oppose it for different reasons. They cannot typically in those situations seek review. They can in the environmental situations where they say the agency didn't go far enough. That may or may not work in some of these situations, but it wouldn't deal comprehensively with it. So I think there's a bit of a disconnect between the problem and solution.
Professor Bagley?
Hi, everyone. I like the proposal. You know, I take the point that this doesn't happen that often, but the Clean Water Act example that Joe offers, it was extremely real and extremely chaotic. I saw similar developments in connection with challenges to the contraception mandate under the Affordable Care Act. There are a bunch of high-profile cases where this seems to occur, and I think part of the reason that I think it makes sense to push for consolidation is because we live in a world with these nationwide injunctions, which often seem to be driven by, the partisan leanings of the judges who are hearing the cases. This is not a criticism of one party or the other. It happens on a bipartisan basis. It seems to me like if you're going to have nationwide injunctions, having consolidation makes a lot of sense. I think it's kind of the worst of all worlds to have both nationwide injunctions and a bunch of district court proceedings, which just means that whoever happens to file in front of a judge who's willing to grant relief, basically drives the stampede to the courthouse. So I don't really see much of a downside. I think you don't get a whole lot of percolation from district courts in a meaningful way. I would support.
Albert?
Thanks. I think maybe the flip side to Nick's point though is, you know, if you consolidate in the district courts, you're going to end up going only through one circuit, right? And so, I mean, you may not have as much percolation as a practical matter in the district courts because maybe they kind of follow each other, but you do cut down the number of circuit courts that could be deciding this. And I mean, look, it's a tough question for me because you could argue that, you know, either way, you're making this more of a problem for the Supreme Court, right? On the one hand, if everything goes through one court, the big court's got to take it if they think it's wrong. On the other hand, if you allow it to sort of percolate through various courts, you could get a total chaos, as Nick points out, and the Supreme Court's got to step in too. So, you know, thinking about it from the high court's perspective, just as another angle to in approaching this problem, I'm not sure which is better, but I do have some worry about not having percolation and forcing the Supreme Court to decide based on a single decision whether they need to take this, because I feel like you're asking them to do a lot of work in the cert review or the emergency docket context, as opposed to, you know, maybe the lesser of the two evils is more percolation, because at least then you forced potentially have a couple more judges and a couple more decisions that have helped the Supreme Court do that work. Because I think one of the real problems we're seeing is you're having the Supreme Court decide on an emergency basis an issue that, you know, maybe one judge has looked at, maybe four, maybe three, right? But anyway, I want to kind of put that out there. So I think this is fraud is not the right word, but this is a difficult recommendation.
Thanks. Professor Levin, I see your hand up.
Yeah, one other issue that I thought I might put on the table is something that's not mentioned in the report, which is the change of venue statute. I mean, it would be possible to deal with someone who files in an inappropriate district to say we ought to, you know, I want you to transfer it out. And I mean, sometimes the judges don't want to let it go because they're the type of person whom the plaintiff wanted to get. But other times, maybe the judge doesn't have a strong preference. But the problem is that the venue statute is currently worded, focuses on convenience. For the convenience of parties and witnesses in the interest of justice, the district court may transfer any civil action to any other district, et cetera. And usually convenience isn't really the issue that is troubling the movement. It's that the district was chosen on a calculated basis. And so maybe so I tried looking at the case law. And what I found was that there is very little authority for the proposition that a case can be transferred under the change of venue statute for reasons that have nothing to do with convenience, but rather to say another court would be more appropriate. So that is where the case law is now. And I think it may bear some reflection on whether change of venue motions would be another remedy for the problem that develops here, and if so, whether the statute should be either changed or reinterpreted to facilitate that happening. If you have multiple filings, then yes, you can use the change of venue statute to justify consolidating them. I think that fits readily within the statutes. But if you have only one, but you believe as a stakeholder that one was filed in a district where you don't think it should be, I wonder if we want change of venue to be an option in that situation. Looks like Alan may be shaking his head, so that could be all
wrong. Joe, I wanted to give you a chance to respond to the last round of comments.
Two comments. The first is there are I'm definitely sensitive to the percolation concern. I think that that's a problem with the current lottery system that assigns a single circuit to resolve a rule. I'm not sure that it would be any worse applying it at the district court level, because it would be 4 judges instead of 3. And so there's at least one more judge that could potentially issue a dissenting opinion or a contrary opinion. But yes, it's certainly a tough balance, and I could easily see the balance being resolved the other way. In terms of, is this really a problem? I think it does come up, maybe not all the time, but the contraception cases is an example. The public charge litigation involved litigation in at least half a dozen circuits, district courts in half a dozen circuits. So it might not be, there are times when there are dozens of challenges to a single rule, and that does pose difficulties for the agencies that have to then litigate all of those and potentially face injunctions or contrary opinions before they work their way up to the circuit court. So I guess I would say that I urge you to consider some method of consolidating when there are many challenges brought, but I'm not, maybe there's another process for doing so.
Thanks, Joe. Are there others or follow-up comments on this final proposed recommendation? Okay, seeing no hands or chat notations, we wanted to close by, as many folks have noted, Joe's report is excellent and quite comprehensive. And so we wanted to ask if there are recommendations that should be considering that are not on this list of proposed potential recommendations. So just to give folks an opportunity to raise additional issues that we can think about recommendation language for that aren't on this list already. Professor Sahoni?
I wondered whether what happened to the idea of putting everything in the DDC, because it seems to me this is related to what we were just talking about, that the issue with the consolidation lottery is that if you have a challenge, if you have a bunch of challenges to like the contraceptive rule or to a Trump policy or something, you're going to be lotterying amongst only blue state courts or lotterying amongst only red state courts. And so what are you really gaining by having a lottery? You might have a bunch of challenges, but all of those challenges are going to be brought in, forum shopped forums. So the DDC with its many judges in one place offers a greater opportunity to have differences amongst judges in those multiple lawsuits. And so I just wondered, after that very good discussion and review of all of these options, I wondered why the chosen potential recommendation was consolidation in 2012 rather than sticking everything in the DDC, where you'd get this sort of within district percolation.
Joe, did you?
I think, oh, sorry, I think that is one approach that would at least solve the forum shopping issue. I think the two potential downsides are, number one, to the extent that it starts to create a more specialized court, as I kind of argue in the report, scholars have not been very kind to specialized courts, the federal circuit being a frequent target of attacks. And whether or not that's justified empirically, I'm not sure, but just I would worry about creating a situation where the negative aspects of a specialized court would come to be in DDC. Now, challenges to federal rules may not happen with enough regularity to raise that issue, but that would be a concern with creating one court that hears challenges to rules. The second concern is that it could make appointment to DDC all the more political, knowing that they will be handling these high-profile matters. That may already be the case because DDC is already the, where a lot of these things happen, so it might not change anything. But it could. So those would be the two concerns that I would have with that proposal. But I think that's definitely worth considering.
Thanks. Could I, Joe, ask you one clarifying question, which is whether, and I guess this is a trans-substantive question. When you speak in terms of civil lawsuits or challenges, are you thinking of the sort of, and I know there's a language debate going on that I'm wading into, but are you thinking of sort of initial, the rule is promulgated, that kind of first set of challenges? Or are you thinking of if there was a pre-enforcement challenge brought a little bit later, but that was saying, the rule is invalid because it incorrectly interprets the statute, and I'm seeking a declaratory judgment to that effect? Do these recommendations encompass those enforcement side challenges as well?
I think they should, and I think they do. I would need to think more about that.
Okay. Are there other potential issues or topics that folks here would like to suggest that Joe think about and the committee staff think about when drafting proposed recommendations for the committee to consider? Okay. Thomas, I just wanted to note that I see your comment in the chat about audio issues and the substantive point. So we'll note that down in light of the audio issues. Okay. Well, great. Then I think we're going to finish up a little bit early today. So just wanted to thank all the committee members. Well, first I wanted to thank again Joe for his hard work on the report and these initial ideas for recommendations. And to thank the committee members for this really productive discussion today. We have another meeting scheduled, at which point we will have, I'm sorry. It's clapping, not hand raising. Thanks, Professor Soni. So we have our second meeting, at which point we will be considering recommendation text. That's Wednesday, April 3rd. It'll be scheduled from 1 to 4 p.m. Eastern, and we will reconvene then. Kasia, is there anything you wanted to say to close us out? Okay, great. Then with that, I think we'll call the meeting to a close. Thanks, everyone.
Thank you, Kirti. Excellent job. Thanks, everyone, again.